May it please, Your Lordship.
No, this is to be placed there. No, it can be put here only, no? In place of this one. We don't need to pay. For the whole year, we have this.
May it please, Your Lordship.
Get the, no, get the, is the, what is the, inside the number. We used to have it side by side. That's yes.
My Lord, the writ appeal, we may be permitted to move on 10th, my Lord.
Very well.
DPO.
May I please, Your Lordship, in item number 31, there is some typological error, Lordship. Today it has come for first time, Lordship. I may be allowed to correct also instead of 6. 31. I am for the appellant.
You want?
To correct
So,
typological error.
learned council, government council, RB Bora submits that certain corrections are necessary in the appeal memo.
Appeal, no, instead of this.
She may be permitted to correct the same by filing the corrected slip in the registry.
Lordship, if Lordship permit me, I can by hand correct.
No, you file a
File it,
corrected
Madam, we are accepting your
synopsis.
physical petitions. That is
Yes.
quite sufficient.
You file it in the court.
The things are going to change very soon. You will be required to file everything in e-filing mode.
Deeply.
Prayer allowed. List after 2 weeks.
Deeply. Please, Your Lordship. Lordship, I'd like to mention item 29 of today's list with the concern of the other side, Your Lordship.
Counsel for the appellant has moved an adjournment slip. The other side has no objection. List after 4 weeks.
Obliged.
There is a problem with power failure, frequent.
But
That's happening very frequently.
some work for
Maybe
governor.
upgrade or something.
All right.
So what do you want? You want us to take it first or what? Is there a request to take it up first? We can take it so that the officer is relieved.
Normally when the officers.
No, yes, call out the matter. It's
Item numbers 21 to 24 as per second.
mentioned to be taken up first. Correct. Let's take them on order.
May it please your lordship.
They also have
Yes, precisely. Mr. Saikia,
Lordship.
we propose from henceforth, unless it is inevitable and unavoidable, the presence of the officers through VC. When they come to the court, they have the excuse not to work for the whole of the day.
Lordship.
So in Rajasthan, we had adopted that. Officers from Jaipur used to appear in the Jodhpur matters through VC. We gave them a fixed time,
Lordship.
12:45 through VC.
Lordship.
So only 15 minutes time was required.
Lordship.
And why not use the technology when we have it?
Exactly, Lordship.
So unnecessarily calling the officers in court is no use, unless it is inevitable,
Absolutely.
maybe in a contempt case or something like that. Otherwise, you are brief.
I fully agree, Lordship.
You would
In
agree,
fact, for
obviously.
today for the first time I'm appearing in this case.
Yes, yes.
There's a last
Uh,
order, Lordship.
Have we informed the Other
We
side.
have not informed. That is why I did not make a mention.
Mr. Courtmaster, inform the other side, then we'll take it up.
Yes.
The petitioner side, let them come.
In fact, on the last 3 occasions, the petitioner side's counsel was not appearing. In any case, we'll try to inform them.
Try to locate it.
Yes.
Item number 1 for motion.
Instruction of.
এটা মটন আমগুলো একটু নয় জানো? আমগুলো ফাইল করে যাবেন।
Yes, please.
Me, please, your lordship, this public interest litigation against the misappropriation of government fund, lordship, and the National Health Rural Mission, lordship. And this has come to the light in the CAG report, lordship, received by the petitioner through
Strategya,
RT
you need
application.
to respond.
Lordship, there is a trend now of this petitioner. This is the first objection. After an inspection, an objection has been raised. After that, several communication had taken place and on all these objections were met subsequently. They found out the first objection everywhere, Lordship, that CAG. They go to the offices and do the inspection, like my office also. They come in a year. They find some objection, then we have to meet it.
Yes, right.
This is precisely what is being done here. Regularly, they are doing the first inspection report they procure through RTI. And thereafter, Lordship, they try to give a projection that there's a huge misappropriation of fund, which in fact is absolutely incorrect. Subsequent communications, they do not find
They
out,
don't place it on record.
don't place it on record. And next day, tomorrow, it will be a big news in the newspaper, blaming the government.
Is there a order subsequent or any communication subsequent to their petition?
This is of 2011, 12, 13, 14, 16.
Okay.
Subsequently, we government are in much better position. If we find anything wrong, we are ourselves put them in behind the bar. We start the department. There is absolutely nothing of that
There
sort.
is annexure J, if you can have a look at please. The letter under your signatures. Or no?
Annexer J, Lordship. There, Annexer B is the first report.
262.
Wait, wait.
Someone else? Okay, he is the petitioner. Under the petitioner signature.
Yes, yes, lord, this is the petition.
You saying this is the 18th petition?
They file a case now in 2023
Lord,
just to build up a case.
Okay.
Let the police do the work. If the police are not working, then they can always come before the magistrate. This honorable court in the PI Lordship is not a magistrate court to monitor this.
Naturally. But all the same, we would like your response. Before we can pull up the petitioner for filing repeated petitions, to just give out a small response.
Yes.
What has been done?
Yes,
what
Lord.
actions have been taken.
Yes, Lordship,
And
because that is
actions have
required,
been Taken before this petition came to be filed.
Lordship.
Even if we get a hint that they have been intimated about the steps taken, then probably we can direct even the sort of stopping or restraining the petitioner from
Lordship.
approaching this court again and again.
Lordship,
As I'm told that this is the 18th petition.
exactly, Lordship.
yes,
So you just file a response regarding the last action,
Yes, Lordship,
then we'll take.
Lordship. No notice may be issued in this
Need
case,
not.
Lordship. And they may be restrained from giving newspaper publication tomorrow, Lordship.
We have not passed any order. We'll let you know. In Rajasthan, the similar thing happened.
Lordship,
The lawyer argued something. There was nothing in the order. And despite that, things were published.
yesterday that child marriage case, Lordship, the interaction with today in the newspaper is a completely different picture given. I was shocked to go through the newspaper,
That's why I don't even.
as if Lordship has fallen very badly on the government. Yes,
As a matter of fact, unless the order is uploaded, they are not supposed to print anything.
now nowadays this live streaming, Lordship, they made out a lot of own ideas.
That's right, that's right. Well, Honorable Supreme Court has said that we can ignore these things.
We can ignore, Lordship.
That's why I don't even open the newspaper.
Excellent.
So you just
We'll file a short affidavit giving their modus operandi, how they are perform.
This one is granted. Short, time to file a short affidavit in response to the allegations set out in the petition.
Lordship, deeply obliged.
List on
13th, if it is convenient to this honor, 14th.
Item number 2,
There was a lawyer who was indulging in this kind of things at Lapan. His practice certificate was there and he's behind bars. Blackmailing.
May I please, your lordship?
yes.
This matter, my lord, relates for wrong recovery proceeding has been initiated.
You have a remedy before DRT, sir.
Lordship,
Statutory remedy. Why should we entertain the writ
but
petition?
question is, my lord, natural justice violation bill. Because without issuing notice to the guarantor, demand notice was served, my lord, that is page
All
page
these
60.
issues Can be raised before DRT, sir.
No,
Supreme Court says authorized officer,
But-
State Bank of
But
Private.
lordship, when the natural justice violated, because lordship is itself impugned, because lordship, prior to issuing demand notice, the assembly position was taken. The annexer 3, my lord, page 19, have a look, lordship. Because demand notice was issued on 20th December to 2021, but the possession notice itself reflected that first day of October of the year 2021, possession was taken. That means prior to issuing demand notice. That is, my lord, the wrong recovery proceeding initiated. And without issuing any notice to the guarantor, my lord. Now guarantor is in trouble, my lord, because he has not acknowledged whether demand notice was served to him. So principle of natural justice is violated, then this court has entertained.
Let us see any judgment that on this ground we can entertain the writ petition.
Lordship,
A judgment post 2022 of the
Yes.
Supreme Court.
now, Honorable Supreme, this judgment, my lord, Odisha High
Sir,
Court,
you are citing a judgment of 1985
The two Orissa.
and that to Odisha High Court.
but division,
Supreme Court authorized officer, State
but,
Bank of
but
Private.
Supreme Court judgment followed this court, my lord. When
All
principle,
right, sir, have a look at this.
when principle of national paragraph, my lord,
Sir, can you have a look at
para 12, my lord.
Mr. Counsel, please have a look at this
State
statement.
Bank of Private Court, authorized officer.
And when rules of national
AIR
justice
2018,
violated,
AIR 2018, Supreme Court 676, please have a look at that judgment.
but my lord, apparently, my lord, it appeared that prior to issuing demand notice, they have taken possession, my lord. The impugned possession notice itself reflects. So, my lord, notice may go, my lord.
Why don't you have a look into this judgment? We have, similar order has been passed. Have a look at the order. Can you have a look at this order? Similar order has been passed by this bench.
My lord, question, my lord, I am, I have to approach before the DRT, but question is, my lord, the possession notice it itself, my lord, inordinate delay, my lord, because demand notice was given 60 days time, but this possession notice issued after 8 months, 26 days.
So then
So
why
it is-
did you respond to the demand notice? Why did you respond?
Oh,
What
Lord.
prevented you from doing so? All
Lordship,
these objections you can raise before DRT.
no, lordship, so far the demand notice is concerned,
We are
representation
not entertaining, sir.
was made, my lord, that page 18, my lord.
We'll
What-
address, give you a liberty that if you move the DRT within next 7 days, you will be heard without objection of limitation. That's all we can do.
Lordship, one representation was made against the demand notice, but has not
You should have
respond,
approached
has
the
not
DRT
given any
immediately.
response. Because of my lord, COVID-19, he was not in position to repay, but there is no any bad intention, he is ready to pay, my lord.
All right, so dismissed.
Obliged.
So my lord, I will approach the DRT subject to my,
Then after arguing the matter for some time, come on, and counsel petitioner submits that as statutory remedy under the Surface Act is available to the petitioner against the impugned proceedings, comma, the petitioners may be permitted to approach the DRT by filing a suitable application. The only indulgence which the petitioners request pay for is that the application, if filed within the next 7 days, may be treated to be within limitations. Do you have any objection to that?
Within 7 days.
Yes. And
Maybe,
also for the respondent does not object to this prayer accordingly, comma, the instant writ petition is dismissed as withdrawn if the petitioners approve the DRT by filing a suitable application against the impugned proceedings, comma, within next 7 days, comma, the same shall be considered and decided on merits without applying the bar of limitation.
Obliged.
Item number 3.
May it please your lordship.
Yes, please.
My lord, this writ petition has been filed challenging the virus of 43D5 of the Unlawful Activities Prevention
Yes.
Act. My lord, may kindly peruse the 43D5, if your lordship, 43D5. My lord, it is a very restrictive provision. What happened in this there?
Master. Unlawful activities.
Similar to 37 of the NDPS Act, which has been affirmed.
Your lordship, as far as I have overheard your lordship, that's why, as
We
far as
were speaking out aloud, we wanted you to hear it.
my lord, your lordship, may I read the particular proviso if your lordship has it? 43D5. It starts with a non-obstant clause.
Yes,
Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application for such release. Provided that such accused person shall not be released on bail or on his own bond, if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Now, your lordship,
now sir, can you have a look at section 37 of the NDPS Act?
my lord.
And the validity of that provision has been affirmed by Supreme Court.
My lord, your lordship will be, as far as section 37 of NDPS Act is concerned,
Yes, please.
my lord, in that particular provision, there, if I read it, my lord,
Yes.
your lordship will, yes, your lordship is fairly correct that 37 has been upheld, and even the identical provisions of Terrorist Act, TADA, section 20,
Yes.
TADA and POTA has also been upheld. But my lord, your lordship will kindly see that there is a difference in both these provisions. What is
Yes,
there? The difference is that here in the Unlawful Activities Act, my lord, the court has been restrained only to consider materials in the case diary or a report filed under 173. So means, my lord, if your lordship will kindly see section 37.
Yes.
Notwithstanding anything contained in the code of criminal procedure, every offense punishable under this act shall be cognizable. No person accused of an offense punishable for offenses under section 19, 24 or 27A, and also for offenses involving commercial quantity, shall be released on bail or on his own bond unless, 1, the PP has been given an opportunity to oppose the application for such release.
Section 43D.
43D, prosecutor has to be heard, my lord.
Yes.
But the striking difference is what is there is that if your lordship kindly read section 37,
Yes.
subsection section 1, subsection clause 2, where the PP opposes the application, the court
Yes.
is satisfied there are reasonable grounds for believing that he is not guilty of such
Not
offense
guilty of the offense. Yes.
and that is not likely to commit any offense while on bail. My lord, for 37 record is there, it has been upheld. But what is the striking difference in 43D5 is that
Yes.
here the statute has restricted the court not to go beyond the case diary or one's
Yes,
charge sheet.
So you want that the defense also must be considered at the stage of bail. That is your argument.
My lord, no.
Defense of the accused or metals which the accused has in possession, they should be considered at the stage of bail. You want
My
to
lord,
go-
Your Lordship, to a certain extent, let me put my facts in this way.
Yes, please.
My lord, a person who has been arrested by the agency NIA
Yes,
for offences under chapter 4 and chapter 6.
yes,
Now he files a bail application under 437. The concerned court, that is the special court, will be bound by the statute to look either the CD.
Hmm.
If the charge sheet has been filed, then 170 the charge sheet. Now what happened, your lordship? The trial continues. For example, the charges have been framed, the trial continues.
Mhm.
My lord will be alive to the fact that the 43D5 constates a word called prima facie to be true. And prima facie is a set of evidence which on the very first, it is a rebuttable one. So my
Yes.
lord, the charges have been framed and the evidences get diluted.
To that extent, is right. Supposing something comes out in favor of the accused in the trial, so he wants us to read it. That material
Not-
subsequently brought on record of court.
It is not restricted.
Restricted to case that, yes.
My lord, I must bring it to your kind consideration.
Yes, please.
Lordship, there have been two interpretations has been given by this court.
Mhm.
In Jayanta Kumar Ghosh case, it was reported in 2010 for GLT 1, where
Yes.
the proviso of 43D5 was being explained. Then subsequently come Jayanta Kumar Ghosh second case,
Mhm.
where the High Court said, this court said, the riders of 43D5 shall be applicable to a High Court, even when considering a bail payer under section 21(4), which I respectfully disagree, my lord.
Mhm.
Then the full bench judgment of this court has said that no court, there cannot be an inexplicable guidelines that bail to be not to be granted. So bail has to be granted, even after post framing of charges. But
Yes.
the full bench, my lord, that full bench judgment has said the limitation or restriction imposed under 43D5 shall be applicable. Now,
Mm.
against that judgment, the NIA has appealed before the Supreme Court, the SLP was been dismissed. Now, that is the law, my lord. Now, what happened, your lordship? You'll kindly see. Let me, as I have given an illustration. Now, a person whose charges have been framed, and as per full bench judgment, you can grant bail. Now, if in a special court, if an accused moves in bail payer, that, my lord, your honor, the evidences which have brought in the time of framing of charge is getting diluted. The eyewitnesses decline. Material. The court will be restrained to only 173. So that is a very bizarre situation. It's a manifest arbitrariness.
Your prayer basically is not to strike down the provision, but
At
to
least
read
may
the
read down.
words that material subsequently collected during the course of trial.
My
That
lord,
is
at
what-
least it has to be read down. In other way, my lord, the 42D5 has to be read down.
Maybe a restriction before the trial.
No, not even the trial. Suppose the trial is a session of trial and the evidence comes in on it. So whether even the fact that he's bound by what is contained in the case document. This is akin to the interpretation of 319 CRPC in a recent case. That evidence means evidence collected during the course of trial. So let's put the other side in the scene.
All right, then we'll issue notice to the other side. We'll
My
take
lord.
their view and then consider,
Oblige, your lordship.
issue notice. MS so and so appears. You are appearing for Unanopedia
Yes, sir.
for all the respondents. She prays, copy of the writ petition be provided to her. She prays for and is granted 4 weeks' time to file counter affidavit.
Oblige.
Item number 4.
May I please, Lordship?
Yes.
Lordship, by the last directives of Lordship, BTC authority was directed to file its affidavit, Lordship. So far, we have received instruction response from 11 departments, Lordship. We are waiting for some other departments, Lordship.
Okay.
Lordship will grant me some more time, Lordship. In the meantime, we'll file our affidavit.
At the request of Mr. P. Nayak, Learned Standing Counsel, BTC,
Lordship,
a further time of 3 weeks is granted to file
may
the
make it 4 weeks.
4 weeks to file the necessary affidavit as directed by this court by the order dated 1/2/2023. Mr. T. Devi appears for the petitioner. List up to 4 weeks.
Deeply obliged. Item number 5. Material also. Right, according to-
Already reported.
My lord,
Material also.
in item number 5, my lord, I am appearing as intervener. I filed an application yesterday. Assam Gorkha Assembly, there is a major registered organization of the Gorkhas in Assam. Because their status as protected class has also been put on challenge by the PIL. So we have filed the application yesterday for intervention or implement. My lord, can it come next week? Along with that, it is not taken in the file.
Any objection, sir? If
Anyway,
his
my lord,
application comes in,
objection, my lord, whether he is locust anyway, my lord, because he wanted to
if
be.
the application is there, we'll decide it. We may not accept the application. That's a
That is
different thing.
up to-
They certainly have locus because they will be affected by any order.
Anyway, my lord. But and another order is the last order, my lord. Actually, government was supposed to bring the records today, my lord. So that also your kind of last order, my lord.
That's first February.
Yes, 1st January,
Because of the permit.
last part, my lord.
As far as these records are concerned, my lord, I have checked up, my lord. The process which was undertaken for declaring them, my lord, as protected class,
Mhm.
is available in different document. If your lordship permits, my lord, we'll file an affidavit recording.
That will be better.
That's-
Necessary bulky record.
My lord,
Are we going to
My lord.
sift
Yeah, that
through
will
the
do.
record?
yes,
That will
That
be.
will not be practical.
my
Yeah.
lord. Lordship will give us 3 weeks time, my lord.
So, Mr. Mazumdar, then additional Court General submits that as the record referred to in the order dated 1st February 2023 is very bulky, he would file the substratum thereof in form of an affidavit within next 3 days. And Senior Counsel Shri
RP Sharma.
has moved
RP Sharma.
that he has moved an application for implement oblique intervention.
Yes.
The registry is directed to tag the same with the file and list it for orders on the next date,
I'm praying for 3 weeks time.
3 weeks, 3 weeks.
Available.
So his application will come earlier or it will come along with that.
Along with-
Same day.
Okay.
available.
Yes. The councils are here. All right, we can take it up.
Item numbers 21 to 24.
Yes. Lordship, I am in 22 to 24, your lordship, 21, your lordship.
I am in 21.
Right.
Petition.
Yes. Direction.
Designated vending zones.
Affidavit filed by the Commissioner of BMC.
Yes,
Page 35.
you're referring to page 35.
35 is another one.
Yeah, what is he saying?
35 whom? The last page. 8 vending zones were there. And they are operative. 8 vending zones. Out of the vending zones, some vendors are still doing their business level.
Mhm.
And that's the thing. We are not replying this affidavit. The only thing is that they may confine their business in the vending zone only. That is our.
So that
humble
action will definitely continue. Why do we apprehend that they will not take action against the vendors who are working outside the vending zones? What is the material to believe that?
The only thing is that very tangible because in front of RBI, Reserve Bank of India, they approached to Pangbazar flyover. Some still
Sir, what
market is
happens
going-
is that street vendors, they run lorries, hand carts. So if he even is moving and we allege and we presume that he is not working inside the vending zone, that becomes too harsh. These are poor people, they have to earn their
Yes.
livelihood.
because vending zone may not accommodate them also. Because the limited area is there.
Well, we don't know, that is for the authorities to consider. We can't preempt that they will disallow other people from coming into and giving you competition.
We do appreciate you.
Lordship, so far as 22, 23 and 24 are concerned, your
Yes,
lordship,
please.
those petitions are by Street Vendors Association, your lordship, that's a registered association, your lordship.
Yes.
They have come up with a plea, your lordship, for implementation of the particular act, your lordship, enacted for
So
them.
first we close this PL number 15
Lord-
oblique
Lordship,
21.
lordship.
Heard learned counsels for the parties. This PIL was filed by the PIL petitioner seeking appropriate orders from this court for removal of street vendors from all the footpaths of Greater Guwahati. More particularly, the purportedly unauthorized traders causing hindrance to traffic and pedestrians alike. This court, on earlier occasions, passed several orders pursuant to which pleadings, affidavits have been filed by the respective departments, more particularly the Guwahati Municipal Corporation. Full stop. Pursuant to order dated so and so passed, the officers of the concerned department, namely so and so, so and so, so and so, are present in person before this court. Upon hearing the learned counsels for the parties and upon due perusal of the affidavit, the counsel for the petitioner has agreed that in terms of the communication reflected at Annexure I in the affidavit filed on behalf of GMC, that there are about 8 vending zones which are located, and it will house about, it will provide facility for vending to the traders, to about 599 numbers of traders.
Is there a survey on how many street
Yes,
vendors are?
one survey was done about 5 years ago.
Okay,
So we found a figure around 7,000 at that point of time. Now presently another survey is going on.
sir, so Mr. Saikia, providing 599 spaces as against 7,000 vendors, how would that serve the purpose?
That is why, Lordship, there is acute shortage of vending zone areas also. And one vending zone area we have designated in Fancy Bazaar, which has not been occupied till date. The others are occupied.
Why?
But
it's not
every
being
day,
occupied?
if we remove some of the vendors, they go there and new set of people comes.
That will come
That
in.
is the problem.
That will come in. That is a problem all over the
across
world.
country.
All over the world.
Yes, Lordship. Only
over the
thing
world.
which can be done now is that there can be certain timings. What regulations can
there.
be,
You
that will be a practical solution.
regulation can be there area wise,
Lordship.
because to totally put a restraint on them,
Yes.
that would be directly depriving them of livelihood.
If I may make a submission, Lordship, if
Yes.
Lordships give us some time in this case without disposing it off, let us come out with a proposal that there should be some time. During that time, the vending zones, vendors can operate on the footpaths, basically on the holidays or sometimes when there is not much rush at that point of time.
But you have to identify.
Yeah, we have to identify, for
Right.
that exercise, we need some time. This is what we discussed yesterday also.
Because
We want a
this is a
solution
problem.
also,
this is a problem both ways.
both ways.
For the people who have a right to move on the footpaths, not having the space,
Exactly.
they face a threat to their life. And at the same time, the vendors.
The,
So
the person, pedestrians also have a right on the footpath.
that's true. That's true.
I think the other day, one of the High Court of South India passed a judgment.
We have done it at Rajasthan.
Lordship.
Same the vendors, because there was space there. So
Lordship.
we directed them that you should move to the
Yes,
designated vending zones.
yes, some, in fact, some, suppose there is a motorcycle garage, they put their motorcycles on the footpath also.
For that, the officers have.
Officers, we do it, Lordship. It's like a hide and seek game.
Yes, that's.
We have to, we can be very harsh also. But again, welfare state, all these things comes. Human problem,
That's right. But yes.
some regulation
the
will have to be there.
Shopkeepers putting their wares on display on the footpaths, that has to be
Stop.
absolutely stopped
Lordship.
without any kind of leniency.
If that direction is also coming from this, that will be easier for us also,
You please go through the order which was passed in Jaipur.
Lordship,
Jori Bazaar is a famous market of Jaipur.
Lordship.
For that, the Rajasthan High Court Division Bench passed a strict order. Anyone coming out into the verandas, seize the shop. You have your own area. You have procured the license thereof. You can't come out onto the footpaths.
Lord.
That is absolutely unacceptable. Then the next step is they come out on the road. So that we'll find out that order, and
Lord.
maybe we'll the vendors, street vendors apart, but at least the shopkeepers, they
Lordship,
should not be allowed to come on to the.
exactly.
So. We'll defer it for the timing.
We'll defer it for the timing.
How
We'll
much,
get that order.
Lordship.
how much time would you require for to
Two
make an
weeks time,
inquiry?
2 weeks time may be given to us so that we find out some regulations and place it before this honorable court. If that is incorporated in the order, that will be
As jointly paid list on. We'll have it on 21st March.
Lordship.
The personal presence of the officers is dispensed with for the next date of hearing.
Let all the or case come together.
Otherwise.
If required, we shall secure their presence through video conference. The
Lordship,
court shall require them to appear through video conference.
Lordship,
Unless otherwise directed.
Lordship.
Your lordship is fixing it on 21st.
21st. Is it all suitable? Okay.
If I observation is that they will furnish a this regulation before this honorable court.
In the meantime, the authorities of the corporation, is municipal corporation,
Yes.
shall
In consultation with the police.
in consultation with the police, propose a plan for systematic placing of vendors in thickly populated areas.
Lordship. Highly obliged, Lordship.
Item number 6 and 7 of daily list.
May it please your lordship. Lordship, in this matter, it was originally a habeas corpus case, your lordship. These, my set of petitioners, your lordship, I'm appearing in item number 6. They have been in the Silchar jail. Also, a part of it is designated as a detention center.
We
your
we
lordship.
call Mr. AG. Mr. Advocate General. Call him. Yesterday, the statement was made, only 200 people in the, what was the name?
Walbara, Matia.
Matia. Then why they are in Silchar jail? They have been declared as foreign nationals.
They are convicted nationals.
They are convicted, okay. That is a different situation,
In
yes.
this case, your lordship, before, at the time of their conviction, also when they were arrested initially, they were in possession of UNHCR issued refugee cards, your lordship. So
Mhm.
they claim to be refugees. And your
So
lordship,
your prayer is that they should be shifted to Kashmir.
that was, your lordship, an arrangement that this honorable court tried to seek.
But
That was, that's probably not possible, your lordship.
Mhm.
But there are, otherwise, there are guidelines also
Mhm.
of the Ministry of Home Affairs to deal with refugees.
you've seen the response of the government of India, wherein it is stated that India is not a signatory to the 1959 UN, 1951 UN Convention.
Yes, your lordship. But otherwise, the government of India has its own guidelines for dealing with refugees, your lordship. If I may kindly place them on record.
Saikya, this is a matter, of
Lordship.
course, they are convicts, but they have already served their sentence.
Lordship.
So can it be considered to shift these kind of persons also to this Matia center? You already have a lot of capacity.
We have.
So rather than keeping them in prison after having served the sentence, they have served the sentence.
Yes, your lordship.
So thereafter detention in prison would not be justified. It can be in a correction facility or whatever you call,
Lordship.
unless the deportation takes place, unless and until. Till then, keeping such persons in prison, how can it be said to be justified?
Let me obtain instruction on 13th, Lordship. The other cases are coming.
Other cases are coming up.
So on
We'll
that
have
we
it on
made-
13. We'll try to find out a solution. Maybe they can kept at the detention center rather than the prison.
At the prison.
But then you'll have to find out number of such persons. It
Lordship.
might be quite large. That would again put.
Yesterday, I found out that it is only 94 now there,
Okay.
but there are 6 centers. So these 6 centers total is 222.
Okay.
Only from last month, after the Gujarat election only, this was functional.
Mhm.
So first center, 94 are there, the rest will be taking the place, but it will not cross 220.
It's okay, but the convicts, you have to
No,
serve the
that-
sentence. Let them not be kept in the prisons.
No, definitely not. Only those child marriage persons, Lord.
We are not, we are, right now, we are on the.
On a different-
who have served the sentence.
Lordship,
These are foreign nationals. Learned Advocate General. She's like, yeah. Appears for the state. He raised for and is granted short opportunity to complete his instructions as to whether an alternative proposal can be made for housing the convicts akin to the petitioners in a facility other than a prison. Re-notify on 13th.
highly obliged.
Your Lordship, another aspect is there with regard to the guidelines, because there's a procedure when somebody claims to be a refugee, there's a procedure for application for long-term visa, Your Lordship. So there also, of course, they cannot move around, Your Lordship, but this is the guidelines of the Ministry of Home Affairs, Your Lordship.
Mhm.
This has not been followed, Your Lordship. So if.
But that the Union of India has to answer. Have you provided a copy of the guidelines?
Yes, Your Lordship, in the original petition, the 2011 guidelines were there. In
Mhm.
another case, similar matter that is pending before the single bench, Your Lordship.
Mhm.
There, it was placed that there have been
So
new
far as,
guidelines.
gentlemen, so far as your plea of habeas corpus is concerned, that is only limited to the aspect that they can't be kept in a prison. To that extent, you are challenging their detention in the prison after serving the sentence. So whether under the guidelines, they are required to be provided visa or not, that is for the single bench to consider.
But that is a different case, Your Lordship. But this is a
So then
different-
why you are making this prayer? Why you are making this argument?
because
In a case of illegal detention, what the court is required to see? Alleged illegal detention. What is the scope of habeas corpus petition then?
Your Lordship,
You have to put the question to yourself.
Your Lordship, because this guidelines at the end of, if they're not allowed the long-term visa, then this guideline says that they would be put in the detention center in that case, Your Lordship. So
So ultimately, the question of grant of visa or otherwise, that is not a subject matter of a habeas corpus petition. Can't be. For that, you have to approach the single bench by a separate petition.
Your Lordship, this,
You just think over this
Lordship,
in the meantime, and then get back to the court on the next date.
Your Lordship.
Deeply obliged.
Much obliged.
Matter number 8,
First one is a repeal.
May it please also.
Yes.
In this particular appeal, Lordship, we have challenged that whether the notification issued 162A will be retrospective. Our appointment was earlier. We have been appointed and we have, our appointment is for lifetime as per earlier provision of the act. Now, Lordship, they have amended 162A and they said lifetime will be 65 years and 65 we have to repair. And Learned Single Judge has said that is retrospective. Lordship will kindly see our appointment order. Appointment sonot, that is Lordship, kindly see at page 61, Lordship. Page 61,
Appointment as a village head.
on date or suspension,
Page number 60.
61, Lordship.
Executive instructions.
On date or suspension of Gambura, this sanad has to be returned.
Yeah, basically.
Okay.
Basically, mediation, settlement,
Right, right.
marriage.
Okay. Yes.
But you will see the earlier notification where 162A, removal of Gambura, Gambura can continue to function till time he is physically and mentally fit to carry out the duties and responsibilities assigned to him. So earlier, this is the provision. On that provision, we have been appointed and we are continuing, Lordship. Subsequently, this notification has been issued amending the 162A.
Who is
and
who was the appointing authority under the existing provision?
Deputy Commissioner or existing, Lordship.
Where is the original provision? Have you
Lordship, this is the original.
Please, that is. Old lady. Hindi का शब्द है basically.
162A, Lordship.
Yes.
Gambura can continue to function till the time he is physically and mentally fit to carry out the duties and responsibilities assigned to them. Under this, that provision we have been appointed, Lordship.
The language 162A1 is can continue. It's not sure, it's a directly kind of provision. Otherwise, this will executive instruction. Does it give any specialized right? to Continue. Is there any absolute right of a person appointed as a Gaon Buddha
No, no,
to
no,
hold on to the post?
no, no, no,
Then-
no, absolute right. We are appointed by the
Otherwise,
selection.
These are executive instructions and the instruction says can. The very use of word can say
Gotcha.
means that it is dynamic. It can be altered. So now if there is a proposition and that is a very rational proposition that yes, give others a chance.
No, only thing
Whatever
is,
the idea is.
no, only,
Otherwise also we feel
no,
that
only,
these instructions, they are absolutely contrary to the constitutional provision. Preference shall be given to the family members of the Gaon Buddhas. Why? Why is that so?
Lordship,
Are we still living in the fiefdom?
no, 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 Lordship, this,
Then
that instruction was already Lordship in Mojudar case, in case of Mojudar also, in case of Gambuda also, as per Assam Land and Revenue Regulation, the preference of the Gambuda family is given. That is why from the Lordship, during the period of
we are
British-
living
British-
now in a
British
age of
period,
democracy of the highest order.
Lordship.
So this kind of provision.
Now Lordship selection committee is there, they select the committee, marks is given. Only if there is a Lordship, the marks is equal, then preference will come, Lordship.
That's not reasonable. But then the very nature of the instructions, that is directory, can clearly indicates. They have taken a decision that man who is 65,
Only thing is,
he
Lordship,
would not be mentally and physically fit.
Lordship,
So that is general
my submission
decision.
will be, Lordship, if I'm retired from service, there is no remuneration, Lordship. I'm not getting any benefit, nothing, Lordship. I have served the authority. I'm not getting any benefit after retirement. Other services, we are getting benefit. This is an honorary post. We are giving service to the society.
Others also have a chance to develop the leadership qualities.
Lordship,
Don't just try to stick on to the post simply because you were once selected. That doesn't mean that it can be eternal. We don't feel that the instructions are mandatory in nature, that they cannot be altered.
only thing is, Lordship, whether Learned Single Judge has decided whether it's retrospective and prospective. Intention of
Sir,
the legislature is,
the very language of the existing provision, that itself indicates that it is not an eternal arrangement.
Lordship.
It can be altered. So if
But-
it can be altered, putting a cap of age is absolutely justified. That is in keeping with the spirit of the provision, physically and mentally sound. So they have taken a rational decision that a man who becomes 65.
It will be effective from 2018.
Yes, my lord. In
Yeah.
2016, actually, in the judgment page number 118, my lord, kindly see that. In 2016, my lord, the provision could be made in 2016, my lord. It was given that page number 118 and B, paragraph B.
Yes.
It is said that the executive instruction was amended by way of notification dated 16/1/2016.
You're
And-
reading 118,
2016, my lord. It is in the judgment.
No,
my
no,
lord.
page number.
page number,
Page number 118.
argument of the learned counsel for the petitioners.
No, my lord, it is the judgment.
Yes, yes.
In the edit petition, my lord. This is an edit
Yes,
appeal.
that is
And it's a
right.
writ petition.
So that is what we are, it is para 4.
Para 2, para B, my lord. This is paragraph 3, section B. Brief background of the case.
All right, that is
170.
117. Yes,
Yes, ma'am.
yes, please.
Yes, it is said that the executive instruction was amended by way of notification dated 16/1/2016. And by the governor of Assam, whereby executive instruction 162 and 162A were deleted and new clause 161A was inserted. My lord, this portion was already deleted. Then how come this deleted portion can be again amended, my lord?
What was the new clause 161A?
Yes, that was new clause 61 and this next.
So it has been substituted. It is not a case of reviving that clause. It is a substitution, basically.
Amended.
No, my lord, it was amended and deleted. And then again in this notification 21, my lord, these sections were not. And my lord, in 2018.
How is this learned single judge dealt with this argument?
My lord,
How the single judge has dealt with this argument?
my lord, that was the impugned part of this again. That was the impugned part. That's why we have challenging this.
We are asking you how this argument has been dealt with. Read that part. That the provision which was deleted could not have been amended. That's what your argument is.
Yes, my lord.
So how has the learned single judge dealt with this argument?
There was nothing much specific in this. In fact, my lord, after 2016, 2018 was another notification. In that notification also, our lifetime continuation was there, that notification.
Para 10, please read. Don't go into the hyper-technical aspects of the thing, of the matter. Right of the employer, and otherwise also there is no civil right conferred upon the Gaumburas. They are just given a respective.
Yes,
Respective
certificate
position.
only. A
So all
position.
right, the intention of this amendment is that there should be an opportunity for the others. They should not try to become Lord Dennings.
Yes, my lord, the amendment was for 162 was deleted, my lord. After that, 161 was given.
Thank you. Dismiss.
Matter numbers 9 and 10.
May it please your lordship.
Appeals are yet to be admitted. Central it says appeal by the department.
Lordship, we have received the copy on 28 and accordingly we filed the wakalatnama also. Lordship, we have some objection. 4 weeks
You
time
want
may
to
be allowed. to
file
send out.
objections against admission?
You tell us what you are objecting against the question of law or the appeal itself.
Actually, in this case, what happened, the industry, they avail exemption on substantial expansion on the basis of a report of DIC lordship. Subsequently, we found that that was not correct. The notice was issued to them. And in the meantime, they wind up
They'll
their.
admit it. You'll have the opportunity to argue it finally.
Lordship, we need then 4 weeks time. Lordship, one outstate council also engaged in the matter. We had 20.
We'll admit it and we'll hear it. On the questions of law, you ask your counsel to appear and argue the
When the
matter.
matter is being finally heard, he can argue.
Much.
Unnecessary repetition of the rotation of matters for no good reason is not at all acceptable.
Heard learned counsels for the parties. Appeal is admitted on the following questions of law.
There are two.
Yes, for
appeals.
hearing.
Two appeals, both appeals.
Much.
Matter number 11.
My lord, this is income tax appeal. And the substantial question of law is at page 14, para 13.
14.
Page 14. Whether on the fact and in the circumstances of the case, the tribunal was justified and correct in law in confirming the addition made by the learned assessing officer to the extent of rupees 1,97 lakhs and or by holding that the trading liability of rupees 1,97 lakhs has ceased to exist during the previous year relevant to the assessment year 2015-16, and therefore the aforesaid amount was liable to be deemed as profit chargeable to tax.
Mr. KL, we admitted on this question.
Lordship,
You have not objected.
No, Lordship, I have two submissions. There were the assessing officer added three on three counts.
The same situation which you were there in the earlier case.
But here's this. Lordship,
Admit
Admit on
the question of law. Para 13, page 14. This for hearing.
My
Matter number 12.
May it please your lordship. My lord, in this matrimonial appeal, my lord, I am assailing the judgment and decree dated 2022, my lord, passed in FC case 180 of 2021. At the outset, my lord, I just want to point one thing, my lord. The judgment has been annexed, but so far the part of the decree was concerned, my lord. My client was yet to procure and produce, supply it to me. So, my lord, that has not
This is
been.
13(1)B. How
My
can
lord,
it be
no,
appealed?
Special Marriage Act. 27(1)B and D was the application.
Mhm.
Thereafter, I, being the wife, appeared, contested by filing written statement. There was a reply to my written statement counter claim. Thereafter, my lord, there was an understanding between the parties insofar as monetary aspects were concerned.
Mhm.
To that effect, my lord, a joint compromise petition was filed by both the parties. That petition I have annexed.
49.
47, my lord. Page 47 is the joint compromise petition filed by both parties.
Right.
And thereafter, my lord, on the next date, which was fixed for necessary order, a petition was filed by the wife, which was in the nomenclature of an admission petition, where she said that she is admitting the allegation of desertion. And to that effect, she says that now that it has been settled between the parties, money has been received, so she wants a decree of divorce to be granted. On that count, my lord, the judgment has been passed where in the judgment, it has been recorded that since this is an admission, so the decree of divorce is granted on the grounds of cruelty as well as desertion. The stigma of the ground of cruelty remains, my lord, because only of this reason we are before this honorable court. The judgment, if your lordship sees, start from page 65. The relevant part starts from page 66, paragraph number 6.
File a review.
Review.
My lord,
You file a review.
File a review. We give you the liberty
before the
family court.
But my lord, otherwise, if your lordship, my lord, sees
Why?
my lord, that is
Illegal in the judgment. You will have to tell this is a compromise decree virtually.
that is there.
Admitting desertion, the consequential finding of cruelty may not be so happily worded, but desertion in a marriage is by itself a cruelty. There are judgments to this effect.
My lord, my counterclaim explains the reason why I deserted. I was subjected to cruelty. That's why I had to desert. I had to save my life as well as the life of my child. So, my lord, that perhaps may not amount to.
Just file a review and get it rectified.
I'll leave it up to your lordship.
Heard. Learned counsel for the parties. This appeal is directed against the judgment and order dated 2012-2022, passed in so-and-so case by Principal Judge Family Court, Kachar, Silchar. Full stop. The petition was filed under section 27(1)B(D) of the Special Marriage Act 1954 by the respondent husband, seeking a divorce from the appellant on the ground of cruelty and desertion. During the course of the proceedings, a joint application was filed by the parties seeking divorce on mutual consent. The grievance of the petitioner is that although on the basis of the petition file, the court had granted divorce by the impugned judgment dated 2012-2022. But para 7 of the judgment, the ground for divorce was recorded as grounds of cruelty and desertion. Full stop. Para. Learned counsel for the appellant submits that this has the effect of creating a stigma on the appellant, although the marriage was dissolved on mutual consent. After hearing the counsel, after arguing the matter for some time, learned counsel seeks liberty of the court to withdraw the appeal and file a review before the family court. Prayer made is allowed. The appeal is permitted to be withdrawn with a liberty to file a review before the court concerned, pointing out the grounds on the mutual grounds on the joint petition for mutual consent as opposed to the grounds recorded in the order dated so and so. Appeal is accordingly dismissed on withdrawal.
Matter number 13.
May it please allow. My lord, the matter relates to my lord, whether a reserve category candidate is also entitled to my lord consequential seniority in addition to my lord accelerated promotion. If lordship kindly permits me, I may give a little background of the position in this state, my lord. My lord, there is an act, Assam Act of 1978, in terms of which, my lord, it provides for reservation in direct recruitment and promotion. Now, lordship knows, following the judgment of the Honorable Supreme Court in Virpal Singh Chauhan, where Railway Board circular itself provided that a reserve general category candidate, if he is promoted in the meantime, my lord, he will catch up. Based on my lord Virpal Singh Chauhan's judgment, my lord, Assam government issued a circular in 1996 saying that reserve general category will catch up. Now, in the meantime, we all know, my lord, constitutional amendments were there. Pursuant to the amendment, my lord, on 12/3/2002, there was an office memorandum issued by the government of Assam, whereby it was, my lord, proclaimed that a reserve category candidate will not only be entitled to reservation in promotion, but they will also be entitled to, my lord, consequential seniority. My lord, that position continued. In the meantime, my lord, in Assam, there was a major flaw, my lord. The rosters were being filled up on vacancy basis, not post base. So as a result, my lord, more reserve category candidates were getting the benefit. So, my lord, all these aspects, my lord, and judgment of the Honorable Supreme Court in Nagraj that triggered amendment to the 78 Act. Now, 78 Act, my lord, it does provide reservation in promotion, but it is silent about, my lord, consequential seniority. Then came a circular of, my lord, 29/12/2014, where Assam government said that the reservation in promotion that will not entail, consequential seniority. Then, my lord,
Just a question, just a simple question. Where would the candidate who has been promoted be placed in the seniority list? What would be the procedure post promotion?
Post promotion, my lord, because the consequential seniority was provided, therefore in the promoted cadre, they were getting the benefit also. That was the position until, my lord, 29/12/14, when government of Assam came up with this circular. If your lordship kindly takes the memo of appeal, my lord, at page 45.
Yes.
My lord, this is office memorandum dated 29/12/14. Consequent upon amendment made in Assam Scheduled Caste and Scheduled Tribe Reservation in Vacancies and Post Act 1978, and acceptance of the recommendation of the one-man commission constituted by the government of Assam by notification number dated 24th of October 2013,
which Sri Harish Sonwal IS as the commissioner, commissioned to study and acquire quantifiable data on backwardness of scheduled caste and scheduled tribe, their inadequacy of representation in government service and posts, and impact in overall efficiency in public administration. Following guidelines have been prescribed in order to implement the post-based roster reservation in the matter of reservation of posts for scheduled caste and scheduled tribe in direct recruitment and promotion. My lord will kindly come to 11.1, my lord, 11.11, just on the bottom of page 45.
1.11.
1.11, my lord.
1.11.
Yes, last one at the bottom. These rosters are an aid to determine entitlement of different categories with regard to quota reserved for them in matters of appointment and promotion. They are not intended to determine seniority in the caste. So therefore, by necessary implication, my lord, the mandate of OM of 12/3/2002, which mandated that they will not only be entitled to promotion, they will also be entitled to consequential seniority. By necessary implication, my lord, it was done away with. And to be more precise, if your lordship would kindly come to page number 49, my lord, serial number 14.
Yes.
Page 49, 14, my lord, serial 14. All existing orders on the subject are deemed to have been amended to the extent herein. My lord, this OM was followed by another OM at page 50, next page.
Yes.
And this is more precise, my lord. As per the guidelines laid down by the apex court in WPC number so-and-so, that is Nagraj, and UP Power Corporation, Government of Assam have prescribed procedure as to how to implement the policy of reservation in promotion right office memorandum dated 29/12/14, the other one which I've read. The report of the one-man commission on quantifiable data was accepted by the state government with the approval of the state cabinet. Accordingly, on the basis of the report, the government decided to provide reservation in promotion. These provisions for reservation in promotion are also incorporated in the aforesaid office memorandum. However, the report of the commission was challenged in the Honorable Guwahati High Court by Equality Forum in WPC number so-and-so. The Honorable High Court observed that though state has made provision for reservation in promotion by enacting the 78 Act, which was amended in the year 2012, the implementation of the same would depend on acquiring quantifiable data with regard to two compelling reasons, which exercise has to be carried out cadre-wise in the context of the service where the cadre is placed. That having not been done, the report of the one-man commission would be of no legal consequence and would not enable the state to give effect to the provisions of 1970 Act as amended insofar as reservation in promotion is concerned. The Government of Assam, after careful examination of the observations of the High Court contained in the judgment dated so-and-so, have come to the conclusion that High Court has not set aside the government policy of reservation for reserved categories in promotion. Rather, it strikes down only on the basis of which this policy was adopted. This has not ended the continuance of the government policy on reservation in promotion. In the ruling, High Court has ruled so-and-so. Then lordships may kindly skip over to page 52, para 4, Roman 4. At page 52.
Yes.
If an occasion arises during the promotion process in which the stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are cadres, candidates of reserve category who on merit is entitled to promotion, his or her case shall be considered for promotion on merit if such candidate has not gained seniority by way of accelerated promotion earlier. So my humble submission is, my lord, by way of these two notification, the policy of the Government of Assam with regard to consequential seniority was done away with. Now, what had happened in this present case? Let me come to the facts of this present case. My lord, there was actually, my lord, this was a proxy litigation. Actually, my lord, what had happened in the Department of Water Resource Government of Assam, there was a chief engineer who was a reserve category man, my lord. Now, just to ensure his way to become secretary, my lord, this is a proxy litigation. I'll establish that. Now, what had happened here, my lord? In this writ petition, my lord, there was a gradation list in the grade of my lord, additional superintending engineer. That gradation list was altered, my lord, because of the latest instructions of the government. Thereby, my lord, the reserve category candidate, he was relegated. But nevertheless, he was within the zone of consideration. Therefore, he could not have had any grievance as far as promotion to the next promotional cadre. Now, in that proceeding, my lord, a stay order was obtained. As a result, my lord, the present appellant, despite being, my lord, recommended by the DPC for promotion to chief engineer, she could not become chief engineer. She could not become secretary. She retired. Now, my lord, the issue which falls for your lordship's kind consideration is, my lord, whether the learned single judge was right in the facts of the case in holding that consequential seniority is still there in terms of the government notification of 12/3/2002. Now, I'll just place two paragraphs from the judgment to show, my lord, the inherent inconsistencies in the judgment. If your lordship would kindly come to, my lord, page number 187, my lord. In this writ petition, the learned single judge dealt with two aspects, my lord, regarding, my lord, quantifiable data and whether reserve category candidates are entitled to, my lord, consequential seniority. My appeal is, as far as my appeal is concerned, my lord, we are only on the second aspect, whether they are entitled to consequential seniority. Now, kindly come to page 187, Roman 2, my lord. It is well settled that consequential seniority is a consequence of reservation in promotion and not an additional affidavit, not an additional benefit. Now, my lord, will kindly come to page number 200, my lord. Actually, my lord, there is slight mistake in the pagination. I'll correct it after the matter is over. Please come to page 200, my lord. Roman 9. Yes. Roman 9 para. Article 16(4)(a) and 16(4)(b) being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide reservation in promotion without consequential seniority. My lord, if it is not an additional benefit, if it is automatic, then where is the question of, my lord, state being at liberty to provide for promotion with or without consequential seniority? My lord, the learned single judge, in my humble submission, my lord, has committed a serious error. The learned single judge felt, my lord, that yes, my lord, as far as state of Assam is concerned, there is no, doubt regarding the policy that yes, state of Assam do follow reservation in promotion. But state of Assam has clearly said, my lord, we do not follow the policy of, my lord, consequential seniority. In fact, my lord, before the learned single judge, the state government was directed to file an affidavit explaining the stand of the state. And state filed an affidavit, my lord, that was also ignored. That affidavit, lordship will get, my lord, at page 138.
Then would you not be required to file a review, sir?
My lord?
If something has been ignored from the pleadings, which has a material bearing.
No,
on
my
the-
lord. No, my lord. Perhaps this will not go for review because there are so many aspects are there, my lord. These are only some of the
135.
limb of the argument.
135 or
138, my lord.
138.
Yes. This is the affidavit filed by the state. Para 8. With regard to the statement made in para 7 of the writ petition, your deponent begs to state that OM dated 12/3/2002 issued by the Personnel B Department following amendment to Article 16(4)(a) has been rendered null and void by the subsequent judicial pronouncement, as well as amendment of the SC/ST Act of 2012, wherein state government did not incorporate enabling provision of consequential seniority. Moreover, OM dated 3/8/16 issued by WPTBC reiterates the decision of the government of Assam in the aforesaid amendment of 2020 regarding their position in relation to consequential seniority. Because in Mukesh Kumar, Honorable Supreme Court has said, my lord, it is up to the state. State may have a policy, may not. Supposing state decides no, will not have, then mandamus will not lie. It is in that context, my lord, this affidavit was sought for by the court. And in spite of that, my lord, the learned single judge has held to the contrary. Now, another affidavit filed by the WPTVC department, my lord, that your lordship will get at page 145. Now, referring to that Roman 4 of that 3816 notification, my lord, page 145. Thus, it is seen that seniority in promotion for reserve category is applicable for promotion.
Plain price and backward price.
Yes.
My lord, this is the nodal department for implementation of the reservation policy. I'm reading the second subpara, my lord. Thus, it is seen that seniority in promotion for reserve category is applicable for promotion against shortfall reserve category post only. Those officers of reserve category who have availed an accelerated promotion earlier are not eligible by virtue of their thus acquired seniority in the subsequent promotional process against the unreserved post. That it is respectfully submitted that the issue of consequential seniority to roster point promotee has been dealt with in
Your
OM
contention is that the seniority in the promotional cadre will be worked out with reference to the roster.
Yes.
If they can't claim seniority against the unreserved force.
Yes. The idea is, my lord, catch-up principle has revived. Now, even in my lord Paneer Silvam case, also Honorable Supreme Court has said, my lord, if there is no, my lord, consequential seniority, then my lord, catch-up principle will revive. And my lord, the learned single judge relied upon that Maharashtra case where there was a provision. My lord, in fact, I filed a detailed written argument which is annexed to this writ petition. We have taken all these points. Now, the fact of the now, my lord, there is a new policy with effect from 18/1/23, whereby, my lord, it has been expressly said that there is none. But this case is involved for the period because the judgment has taken a contrary view. My lord, the fundamental mistake in my humble submission.
Then your client is retired, superannuated.
No, my lord.
What difference?
If I succeed, my lord, I'll retire as a secretary of the department because they will hold
Ex post facto.
ex post facto. No, notionally, I'll have the pleasure of retiring as a, my lord, secretary of the department. Now I have retired as an additional chief engineer. Kindly see, my lord. And my lord, my case was recommended by the DPC. I could not be promoted because there was a stay order operating in this case. Now, the fact of the matter is, my lord, what was the material before the learned single judge to arrive at the conclusion that after these two notification and these two affidavit, there was a scope for the learned single judge to take the view that 12/3/2002 notification still holds the field. There is absolutely no scope in my humble submission, my lord.
Yes, please. Yes.
My lord, before I start my argument, two important vital facts has not been brought by my learned friend. First of all, my learned friend has not stated that the lease is still pending. My lord, what has happened? The constitutional validity of a clause of the Assam government depriving us the benefit of RK Sabharwal was taken. Because when we go on merit in a higher post, we go as a member of the unreserved. So this clause 4, I challenged. The learned single judge categorically held that it is against 5 judgments of the Supreme Court. Indra Swani, RK Sabharwal, Nagraj and Jarnail. Because Nagraj was not on the issue of reservation, it was on the excessive reservation. In Assam, the reservation, the rosters are fixed, 100 for the general, 22 for the reserve. We are not asking for, we are not getting our 22. Where's the question of excessive? So the learned single judge, well, the appellant wanted the benefit of a catch-up principle, which was already done away with by the 85th Amendment. Because what had happened, the judgment from Nagraj, from Indra Swani specifically stated in 9 judges that there will be reservation in, there won't be reservation in promotion, but the government, the central government is given time till 5 years. So on 17/6/95, the parliament exercising its constituent power retrospectively gives the benefit to the SC and the ST that they will not only be entitled to the benefit of accelerated promotion under the 77th Amendment of the Constitution, but also 85th. And if a reservation policy is to be effected for the reserve, then 2 has to go. Assam government, curiously, I think nowhere in the Republic since 1950, an OM brings where The specific stand of the Assam government is, we will give you the benefit of 77. That is, we'll give you accelerated promotion. We will not give you consequential seniority. And the learned single judge rightly held in clause page 133 that reserve persons will be going as a member of the unreserved, so they can compete.
What essentially you are saying is that if you give us one, you give us the other. You can't curtail.
You cannot control, because the entire edifice of the constitution, benefit of reservation collapses. In Assam, it has collapsed. It has collapsed. And today what has happened, after the judgment was given on 6th, the appellant wanted to go for a larger bench hearing to delay the matter. And I objected to it before a coordinate bench. One of the coordinate bench, can the coordinate bench take a decision of another coordinate bench if the learned single judge is to differ from the other judgment of Honorable Justice A.D. Chaudhary? The learned single judge will have to overrule 5 Supreme Court judgments. The judgment is awaited. In fact, on the last occasion, the counsel made a statement before the division bench that the 3 connected matters may come up, because this appeal is, the learned single judge on the 2nd count is yet to deliver judgment. So I say that let us wait for it, and we are ready for the hearing.
Why are you asking the division bench to wait for a judgment in the single
Because
bench? When it will come, it will come.
No, well,
It is the other way around normally. That a single bench will await.
Why was the fact that the list was pending, is it not my duty as a counsel to inform the division bench?
Certainly. But
Because
is there we are not stopping the single bench from deciding the issue.
Yes.
But what stops us from deciding looking
I'm
into the merits?
I'm placing facts, because for affidavit, it's my duty as a counsel to place facts. And the connected matters, there was a statement from them only that these all should come up. Where I on that day made a submission that the lease is pending. Lordship has said that let us wait for the lease. It's up to your Lordship to take up. So basically, this petition needs to be dismissed immediately, because it is upholding the Supreme Court's order the learned single judge has rightly held. Because the Assam government cannot give us the benefit, take one and give one, because the entire edifice is broken. Now what has happened, my learned friend has rightly said, the Assam government has landed up in the second chaos. They brought an OM overriding the judgment. And I have challenged it immediately within 3 days, stating that OM cannot override an act we have seen, but this will be the first time where the Assam government is overriding binding judicial decisions, which goes against constitution.
That OM.
Yes, my lord, and learned single judge, seeing the enormity of the issue, because it affects the entire 60 department of the Assam government.
Let us tag that writ petition with this appeal.
Yes.
Read it together.
Yes. It is already fixed on the 27th, on the 16th.
My lord, my learned friend has just now made a statement. My lord, correct facts should be stated. My lord, will kindly come to page 200 for a moment. Please come to that. He said that Assam government in the 70 years of independence, first time has come up with a policy which is against the constitution. Kindly see what the learned single judge permitted, my lord. Article 16, 4A and 4B being enabling provisions, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority.
All actions are to be taken in light of the judgments in M. Nagaraj and Jarnail Singh.
Exactly. No, my lord. My lord.
Even if that liberty is given, that liberty is not unfettered. It has to be in accordance with the Supreme Court judgment.
No, my lord. Whose case is it that Assam government has acted in contrary to the Supreme Court judgment?
He has filed a writ petition saying so.
Anyway, my lord, his case is,
My case.
my lord, he says that after the amendment, especially after 85th amendment, the catch-up principle has lost its efficacy. That is, he'll utter this sentence 20 times during the course of the argument. I can assure you, lordships. My lord, let my learned friend justify that. No, I'm not saying he cannot. He can. He has the right. Now, my lord,
He can go on saying it 20 more times. And
my lord,
no problem at all.
in Nagaraj
Because the
itself,
Constitution-
my lord, in Nagaraj itself, Honorable Supreme Court, after upholding the amendment, said these are only enabling provisions.
So like we'll admit your appeal and
Yes.
we'll connect it with that writ petition. We'll hear the matters together.
Yes,
Yes.
Do that. All right.
because all promotions are stalled.
No. Everything is going on, my lord.
Let it come.
And,
to
my lord-
parties.
Number two period.
appeal
Number two.
is under hearing. List this appeal along with the writ appeal number.
That will be a writ petition. You have filed a writ petition.
Yes, well, now the constitutional validity of
No,
the
no, my
latest
lord,
OM is on this.
Can I come on this? my lord?
363 of
No, let. My lord, what had happened? After this para which I have read, where the learned single judge itself gave the liberty, because there the learned single judge was of the view that since 12/3/2002 has not been expressly overruled, therefore consequential seniority will continue. Now state has come up with a policy that, my lord, in group A post, there will be no consequential seniority. There will be only reservation in promotion. Now that policy has been put to challenge in the writ petition. That petition and this has got no relation, my lord, because number one, my lord, here we are concerned with the period prior to that notification. What was the position?
All right, all right. Basically, the
is emanating from the
concept-wise,
judgment.
Concept-wise, the
Of course,
arguments will
concept-wise.
be the same. So, and you yourself said that now the Assam government has again put the situation in the same position that there will be no seniority after promotion.
Yes.
So if that OM is under challenge, basically the fundamentals in both the cases will be same.
Absolutely, it's emanating from the learned single judge judgment.
Writ appeal 239 is not listed today, I believe.
No, not this.
List this appeal along with writ appeal 239 and WPC
The 363, where the constitutional validity of the latest
363 of 2022.
2023.
23.
My lord, there is one more writ appeal, my lord, which has of course not been registered. That is, my lord, writ appeal with filing number 8026 of 22.
Let that be registered, thereafter we'll tag it.
No, my lord, there is a leave application because we. Okay, let it be registered and come.
No,
Leave has been given.
Then the registry will register it and it will be listed. Then you can
Then
take it
we'll
up.
tag it. We'll tag
We'll
it.
take it up. This-
So lordship is the
Two
latest
writ appeals,
OM of the Assam government, your lordship is pleased.
We have
Very
tagged
right.
that.
It is emanating from the single judge. Because my contention is they have overruled the judgment of the single judge. Obliged.
My lord, their only thing is, my lord, we will be losing our right of appeal
46 and
in that
239
series.
and that writ petition.
That is a division bench writ petition.
No, that's a
Yes.
single bench.
Challenging the
Single bench.
constitution validity.
Yes,
Yes, the single judge's constitutional validity, I challenged it as a
but that
reserve.
was moved before
That
single
was
judge.
struck down. The clause 4 was struck down. And on that, the government never implemented because government took up the plea, we will give you half, we will not give you. It is at that point of time that the Assam government now gives an OM saying that in the higher category.
Mr. Chaudhary, that you will be losing so that.
No,
you
no,
will be
no, no,
losing a
not
right-
at all.
She has already retired.
No, you said that you will be losing a right of appeal.
Right of
Against
appeal.
what?
Right of appeal, my lord.
Against what?
No, because the matter is before the single judge.
But that was the thing I said.
No, single judge has ruled in your favor by striking down
No,
clause 4.
This single judge second time.
Champion of reservation, Mr. Das.
Doesn't matter. The constitutional validity is challenged. The division bench
Absolutely.
can very well hear the matter.
Yes, madam. Obliged.
Matter number 14 and 15.
In this case, if your lordship recall, my lord, I have filed the affidavit day before yesterday, annexing the documents whereby, in spite of this 2017 catering policy, the railway authorities have renewed ex post facto from 2019 to 2024. The affidavit was filed day before yesterday, my lord. Whether it has come on record, I think. Possibly.
The affidavit so far, the affidavit is not in the past. We'll ask the registry to tag that affidavit with the file.
Yes, madam. Would your lordship take up at 2 o'clock today, madam?
Today it will be difficult.
Difficulty, madam, they are trying to create third party right by tendering, floating tender and all. These poor vendors, madam. All over Assam, these poor vendors will lose their right to small, matter which small thing they are earning their livelihood. And they are.
Next week, Friday, my lord.
We'll have it on 9th.
Nine.
Let the matter be listed on 9th.
Yes.
And the affidavit stated to have been filed by the appellants be connected with the case records. Stated to have been filed today,
Day before yesterday, ma'am. Day before yesterday.
day before yesterday. Filed by the appellant be connected to the case records. List on 9th.
Till then, the third party right may not be clear. Otherwise, it will again create multiplicity of proceedings, ma'am.
We direct status quo to be maintained till
My
9th.
lord, till then.
It will take time, my lord, to settle.
So that doesn't matter.
Make a statement then, that you will not be creating third party rights in the meantime.
The
Will
only
record
section I
your
can- but
concession.
The period is 45 days, my lord.
On a
If
status.
you make a concession that till date, you will not be, till next date, you will not create any third party rights.
Till
Let me
10.
have my instructions, my lord, then I'll inform the court within.
Very well.
We are only granting you status quo till 9th.
Yes, ma'am.
Let me have my, I'll inform in 10 minutes. I'll give the statement.
Very well.
Item number 16.
My lord, here, my lord, the appealing work contractor, my lord, he has, my lord, constructed the work under the state government scheme, my lord, in the year 2015. Now here, my lord, the page 18, my lord, the submission of the, my lord, judgment of the honorable single judge, page 18. And my lord, relevant portion, page 20, paragraph 4, my lord. My lord, the submission of the MC Hills, my lord, was to the effect that they are seeking fund from the state government by making supplementary demand. Now that issue of supplementary demand, my lord, is linked to the state government for creation of budget, my lord. But the writ petition was disposed of, my lord, on a very narrow, my lord, narrow campus, my lord, without going into the.
This has followed the full bench, the judgment of this court, Tamsher Ali.
The Tamsher Ali one, actually, my lord, it was the citation, my lord, paragraph 4, my lord, and paragraph 5 of the judgment, page 20 of the honorable. It was the submission of the, my lord, counsel for the MC Hill, my lord. It was
What
the.
has happened after the judgment of the single bench?
After the judgment of till now, they have not implemented the order, neither paid the payment. They're saying, my lord, by the last phase.
That period of 45 days has ended.
Yes.
So they were required to do something.
Nothing
Yes,
was
please.
done, my lord.
Lordship, I am appearing for the respondent NC's autonomous council, Lordship. Lordship, if your Lordship kindly peruse page 43. This is the tender notice.
We are asking you, the learned single judge has, on your submission, disposed of the appeal, saying that you will examine the claim of the.
Yes,
appellant.
accordingly, we have made the list of the contractors, Lordship. We have made the list of the contractors and they are being paid accordingly, Lordship.
Nothing.
As per
You
Tamsher
were
Ali.
to examine the claim of the writ petitioner individually. What have you done about that?
Lordship.
45 days period was provided.
Error
Read paragraph
6.
6 of the order.
Lordship. Lordship, the claim of the petitioner is being admitted, Lordship, and it is being examined, Lordship.
That period of 45 days is gone. When did he submit his final bills?
No, in the 2015, my lord, they are seeking funds till now.
Lordship.
That is their statement.
This is a case of bunch of the contractors petitions. The court are up to hearing, so there over you verify and you feel it the seniority of. Everything है, but simply judgment of the court. They have admitted, उसको payment देना है,
Page 58, the bill, my lord, page 58.
Actually, I couldn't find it. His additional value is not entirely up to him. I thought it was for him. Then he gets a benefit. This is the MC Hills, not the council, autonomous council.
No, it was a state government scheme. They get the fund from the state government. The last page, if your lordship see, page 102, they are still seeking funds from the state government. my lord. Under the, my lord,
Actually,
supplementary demand.
this project is a time-bound project. It was a time-bound project as it was reflected from page 43.
But
That
you
is,
have not dismissed the claim You don't dispute the claim rather.
Lordship, we are not disputing the claim, Lordship.
Then why you are harping on that time-bound project? You have forced rather you have accepted the work of the contractor.
Lordship,
He has given his bills. Now you are supposed to pay.
Lordship, we have sought for a budget from the state government, Lordship. The budget has not yet been released, Lordship. Once the budget has been released, then we can provide him the.
When was the last communication from your side to the state government or budget?
Phase 102, my lord.
Lordship, as per my
2019.
instructions, Lordship, it was in the month of January 23, Lordship.
Can we have your communication on record?
Right now, I don't have. Yes, on record, I can bring it, Lordship. Lordship may give
Bring
me,
that on record, then we'll ask the state government.
Lordship may grant me sometime, not 3 weeks time, so that I can bring it on record. 3 weeks.
That period of 45 days is already over.
Lordship,
You'll be facing contempt now.
you bring it by 10th. Lordship, Lordship,
Yes, paid list on 14.
Lordship.
By council for respondent, paid list on 14.
Oblige me.
I've just spoken to the authorities. The petitioners hearing they're espousing the cause of the vendors association of the Lambing division. And the stalls, those have been vacated in terms of this judgment, my lord, in the Lambing division. Those have not been allotted to anyone and they have not called any tenders with regard to those stalls also. So till 9th, my lord, there is no chance of.
In other places in Assam, they have done. So they will take a plea that we have already floated tender.
We'll record his statement. This is a statement he has made on the part.
With regard to the Lambing division only.
But there is tender. He's saying only with regard to Lambing division, there is no tender.
No, your clients, the persons you are espousing their cause is from Lambing only.
But this association which is there in Lambing division covers various railway stations.
So he's talking of the entire Lambing division.
Division.
Yes.
Mr. B. Sharma, learned standing counsel for the railways, submits on instructions that as on date, pursuant to the judgment of the learned single judge, no steps have been taken for issuance of fresh tender insofar as the stalls on the railway platforms under the Lambing division.
Those have been vacated.
And Guwahati, well, though that statement may not be recorded, this is this period fact panel. The Lambing and Guwahati, we are concerned with Lambing and Guwahati. There's one case.
Guwahati comes under Lambing, my lord.
Then it's all right.
Guwahati comes under Lambing.
I, Lambing and Guwahati railway stations. Accordingly, is the matter on 9th.
Guwahati, Lambing or under. Much obliged.
Lordship has give something because they will go ahead with because they have already sealed. And now if any of the steps taken.
No third party rights are to be created. Till 9th.
Till 9.
Obliged.
Letter number 33 to 35 of supplementary list.
Before my learned friend starts, Lordship, in this case, I am instructed to appear on behalf of the finance department. I was hearing Lordship's yesterday's deliberation. If Lordship wants to remand it back to the department, we have no objection. Otherwise, on merit, if Lordship wants to hear the matter, then Lordship will fix a date for hearing, Lordship.
It's up to you if you want to take a step in light of what has been done by Rajasthan state. That instruction has to be taken by
Yes,
you.
but without interfering with the impugned order, Lordship. Lordship may send it to us. We'll re-examine it by the anomaly committee. And if anything is wrong.
Till then, you would be required not to effect recoveries, at least.
Recoveries we are not doing, Lordship. Because Rajasthan High Court, I had gone to it.
My lord, they had paid us 8,700. They were continuing to pay us and they stopped it only after, my lord, that August 2018 thing had come. Now, my lord, the thing is that the whole exercise was done behind our back. Now, yesterday.
Then we'll hear it on merits.
That would be fine.
That will be the better course of action.
Now, from 2008, they are not getting anything.
No.
So if they finally succeed here or in before us also, they will get everything in area.
That is all right. Then we'll decide it on merits.
Lordship.
Then Advocate General, Shri Saikia, puts in appearance on behalf of the Finance Department, Government of Assam. He prays for and is granted time to complete his instructions. List for final disposal on 26th May,
May.
April, 26th April.
Lordship, could it be 20 in 2 days later, Lordship?
Oh, sure. Let
20
it come up on 3rd May.
3rd May, Lordship.
Third May.
Highly
Fine.
obliged, Lordship.
Much obliged.
Matter number 17 and 18 of daily list.
Yeah, please, your lordships. Lordships, according to the last order, your lordship, an affidavit was directed to be filed regarding the steps taken as per the orders, your lordship, to remove the encroachment from the tribal building blocks of the state, your lordship. That instruction is still awaited, your lordship, because it's 5 districts. Your lordship may kindly grant me some more time, your lordship.
How much
The
time do you require?
4 more weeks, your lordship. It's 5 districts, that's why, your lordship.
Order of Supreme Court was passed way back
Yes, your lordship.
on 3rd February 20.
Yes, your
It's
lordship.
more than 3 years now.
Thereafter, your lordship, those 5 districts where encroachment was identified, so they have already filed affidavits, your lordship. That was filed.
Filing of affidavit would not be of any relevance unless you
Unless you
take
comply.
steps for removing the encroachments. What has been done?
Lordship, steps,
Which are the districts?
lordship, Morigaon,
Let's keep the commission.
Kamrup Metro.
What happened in this case, pursuant to the order passed by this honorable court on 9/12/2019, my lord. Some of the aggrieved petitioner approved the honorable apex court, and apex court has, my lord, passed certain order. I filed in along with my affidavit, my lord, page 25. But my lord, honorable Supreme Court. Twenty-five.
Your affidavit.
Yes, my lord, in my affidavit. In my affidavit, what happened, my lord, we are the, my lord, respondent.
Affidavit
We have
file?
been
Is there an
implicated,
affidavit file?
we have been implicated by this honorable court.
1 minute, we are trying to locate your affidavit.
Page 25.
It's the number.
Impleted as response number 13 to 27.
No, my lord, 14 to 27, my
14 to 27.
27.
Your affidavit was filed on?
17 to 21.
These are basically encroachments by non-tribals on tribal area.
Allegation is that, my lord, but in my case, my lord, what happened, they are the people, they are, my lord, protected by the act, my lord. Because it was in 1958, my lord, this notification was issued by making these areas under tribal belt, my lord. At the relevant time, my lord, more than 50% population of the area were tribal, non-tribal, my lord. So that fact was not considered. Secondly, my lord, what happened? Rule 163 of the Assam Land and Revenue Regulation, my lord, they are protected, my lord. Those who are living there before the notification, they are protected, my lord. They are protected.
It is there.
And honorable Supreme Court has made
File it.
Regarding action in consequence of the order dated 9/12/19.
You are referring to the order 3/2/2020.
The Supreme Court order is 9.
3 to 2025. 3 to 20.
3 to 2020.
2020. Next page, my lord, page 25, is the, my lord, details.
So let the affidavit come then. You have to file the affidavit.
Yes, sir.
5 districts.
It's almost 3 years now.
Yes.
You file it within 2 weeks,
On last
or we are
day,
calling the
the
deceased.
Requested the honorable court to close this PI, your lordship. On last occasion, the petitioner requested the honorable court to close.
So
this
you
PI.
first file your affidavit.
Now this is, this is not in the hands of petitioner now. This is for the court to consider. Find the affidavit.
And with regards to my area is concerned, my lord, based on the affidavit on 9/12, my lord, the order passed. In our area, no encroachment is there. Ma'am. That is there in.
Let
order.
the
Come on,
affidavit, let the
Then we
affidavit,
can close it.
at the request of,
Lordship wanted to know the 5 districts.
at the request of learned counsel appearing for the revenue. Let the matter be adjourned for 2 weeks, enabling her to file affidavits on behalf of the districts.
5 districts, Your Lordship.
Name the districts:
Kamrup Metro, Bongaigaon,
Kamrup Metro, Bongaigaon,
Tinsukia,
Tinsukia,
Sonitpur and Morigaon.
Sonitpur and Morigaon. Full stop.
Lordship, I request 3 weeks.
It is made clear if by the next date fixed, the affidavits as directed are not filed, the court may consider calling the respective deputy commissioners to court in person. Let the affidavit be filed by the next date as directed. List again on 29th March. 29th March.
Matter number 19.
Mr. Lordship, in this case, thought had happened, my lord, 2 persons missing with effect from 26 to 2016, my lord. Accordingly, my lord, the FIR was filed, my lord, immediately, my lord, at page 15, 26th of February 2016. Thereafter, proper investigation had not done, my lord. Accordingly, the representation was filed before the SP and DIG also, my lord.
FIR was submitted.
And recently, my lord, we have received a notice, my lord, from the concerned IO, my lord, stating that, my lord, no clue is found in respect of the missing person, and they have filed the final report, my lord.
If the final report has been filed, you have to take steps of protest petition.
Yes, my
What the
lord.
court can do in habeas corpus now.
Yes. Now, my lord, in respect of other prayer, my lord, at the 10. Prayer 2 and 3, my lord. Prayer 2, my lord, in respect to pay, my lord, compensation, my lord.
File application. Have you filed?
And-
You have to file.
and
Section
similar-
5, the office memorandum is there.
Yes, my lord. And
So have you moved the application?
my lord, similarly situated matter already disposed of by this.
No, first you have to approach the government.
Yes.
You have to file an application. Have you filed an application?
No, my lord.
Then
What is the order you are referring
This
to?
is the similar order, my lord.
no, similar orders will be there only when the government refuses to give you that accord to the prayers made in your representation.
Yes, my lord.
In terms of the notification, you are required to approach the government first.
My lord.
Sorry.
Direction can only consider in light of this. Upon the application being filed, I think.
By the application, the government will consider it in light of this office
My lord.
memorandum.
That liberty may be given, my lord.
No, that liberty is always there. Heard. No, the counsels for the parties. This petition was filed praying for writ of habeas corpus to direct the respondents to produce the corpuses, namely the husbands of the petitioners who had remained untraced since which date?
26 to 2016.
26
of February
26th of February
2016.
26 to 2016. Although an FIR was lodged pursuant to the inquiries made as per the instructions submitted before, as per the status report submitted by the learned senior government advocate Assam before this court. In spite of efforts being put in by the police and the investigating officer, no clue as regards those missing persons could be found out. And accordingly, the final report being FR number 01 of 2023 dated 12/1/2023 was submitted by the police in respect of DOTMA police station, case number so and so. DOTMA police station, case number 06 of 2016 under section 365 IPC. So, where the learned counsel for the petitioner submits that he has two other prayers in the writ petition, namely prayer for grant of compensation in terms of the office memorandum dated
Page 23, my lord.
dated so and so at page 23. 15 November 2014, page 23. Learned counsel for the petitioner submits that in terms of the office memorandum / notification issued by the government of Assam Department of Revenue and Disaster Management Department, the next of kin of the deceased persons, namely the petitioners herein, are entitled to the compensation specified under the same notification. Full stop. The learned senior government advocate does not dispute to the submissions made. Accordingly, this writ petition is closed, enabling the petitioner to approach the government and file necessary applications in terms of the notification or OM dated so and so, pursuant to which the competent authority will make necessary inquiry and pass appropriate orders granting compensation to the writ petitioners.
Within a period of 2 months from the.
Within a period, the outer limit of which should be 2 months from the date of receipt of the certified copy of this order.
Along with the application.
Along with the application.
Logical.
Writ petition is accordingly disposed of in terms of the above.
Item number 20.
One thing clarified, my lord, to whom the application may be filed, my lord.
It is there in the Commissioner Revenue.
Commissioner Revenue. Obliged.
May please. Your Excellency. But this is registered not in pursuant to an incident that occurred in state of Arunachal Pradesh, wherein from the Teju police station, 2 accused persons, my lord, who were accused of committing a rape of a minor girl. My lord, they were dragged out from the police station and, my lord, killed in the Charali of the Teju town, my lord. Pursuant to that, my lord, investigation was initiated. Thereafter, my lord, charges were filed. But very astonishingly, at the time of framing of the charge, the accused, they were discharged. Against that order, my lord, the state has already filed a petition before the Itanagar bench of this honorable court. In the meantime, my lord, during the course of investigation,
the state wanted some footage from Facebook and WhatsApp because the entire incident that was circulated in the social media. But that information state is still to get, you know, they're yet to get those information.
Latest status about this matter. They were discharged from the sections 302, madam. So cases proceeding under the, initially it proceeded before the district judge, session judge.
It's been toned down now.
Yes,
Has
toned
been
down.
toned down to
Toned down to the other sections are there. Various sections are there.
what section?
Yes.
We have a.
My lord,
the order
we
of
have,
discharge, please.
we have those, please.
Please.
PDP.
Including rioting, my lord, 148, 147, 148, 149, 448.
Can we have a look at the order, please?
Discharge order, my lord, yes. I think it is already there in the records, my lord, but I am at 150. State filed criminal petition against state, my lord, that is pending.
And this must be a case of sloppy investigation, apparently.
Yes, Lord.
My lord, it was a mob, my lord, and that is why these dump data are being sought for, my lord, from the authorities of the Facebook and in the United States of America by way of letters rogatory. So this has to be routed through the
The
ministry.
entire charge sheet was based on only call detail records, nothing. This was in the police station, whether the police people were not there.
Yes, my lord. Those were
They,
there.
they did not see the incident. What?
My lord, they were very much there, my lord, because it is their station from where it happened, my lord.
You are representing the state of Arunachal Pradesh.
Arunachal, man.
It's really strange. Why in a case wherein the mob lynching is there at the police station,
Yes, ma'am.
there is no eyewitness. Where was the police?
The
police
accused
people?
in Teju, my lord. The Teju in my lord, that it will be Eastern Arunachal Pradesh. Lohit district.
Were the police officials deployed at the police station not present?
They were overpowered by the mob, my lord.
Overpowered means.
The entire mob, my lord, that went inside the station, my lord, broke
So
things.
they did not identify a single assailant. You mean to,
They arrested six of them, my lord.
on the basis of call detail records?
Yes.
When they had already seen the incident. That means they are hand in glove. What else? You want us to believe that the police guys who were there, they were overpowered and still they were not able to identify even a single of the assailants. That's what you want us to believe.
I mean, I am not saying it. Whatever is there,
Yeah.
I'm speaking from records, man.
But I have a copy of the charge sheet. My lord, I have flag marked the relevant statements given.
Let's see.
There are statements, my lord, there were depositions made that the accused persons, they were seen along with the mob, my lord.
They were definitely part of the mob.
Yes, my lord. And despite this discharge order, my lord.
But that order is under challenge.
Yes, my lord.
Yes,
That
So
is
it would be premature for us to make any comment.
true, my lord. Very
Might
true.
prejudice the outcome of that.
Yes, true.
Decision.
Very true, my lord.
Now, what is the status of the
My lord,
retrieval of the information?
they wanted additional information, my lord, which we sent on 22nd of February 2023, and that has been sent by the Ministry of MOH, my lord, on 1st of March. My lord. On 1st of March.
They won't give information. That's the problem.
This we have received today.
Even if it is under feasibility, it will be done as a secondary evidence. So how it will be taken on record in the sense of if I leave.
What would be the purpose of video footage? 65B.
That is, my lordship is correct. 65B is there.
Be a video circulating on the social media.
Yes, madam.
There will be no evidentiary value at all. So let us wait for the outcome of the criminal petition.
That's true, my lord.
That's better.
Yes, my lord. And state will expedite that proceeding if possible.
It is submitted by the counsels that the application or the petition challenging the discharge order dated so and so passed by the Sessions Court, Lohit District, Sessions Court, Teju, Lohit District, is presently pending before the Nahalagun bench of Itanagar of the Guwahati High Court. Post office. Under the circumstances, we deem it appropriate to defer the matter for
Waiting. Yes.
8 weeks, awaiting the decision of the court in the petition preferred by the state of Arunachal. Let's stop here for 8 weeks.
Matter number 25.
Deeply obliged.
Timely person for the timing only.
We will have it up to 2 weeks. Council for the petition, please, list up to 2 weeks.
Lordship, can you give the last for the lordship? On direct.
Council was not present.
They have not yet filed, that is not filed.
They have not filed affidavit. Locus,
Yes.
you have not filed that this was only adjourned for considering the issue of locus of the petitioner. So that will be considered in during the course of oral arguments. We'll see it in the next date. 2 weeks.
Matter number 26.
May I please, Lord?
Yes.
Lordship, as per the order dated 25/1/2023, my lord, we have gone to the official, my lord. But my lord, they are unable to trace out the report, my lord. So, my lord, the re-step may be taken, my lord.
Fresh steps.
Fresh steps.
Learned counsel for the appellant is permitted to take fresh steps on the sole respondent by registered post AD with AD. List after 2 weeks, 3 weeks.
Republish.
Matter number 27.
May I please, Lordship? My lord, a status report has been called for.
I am on behalf of DNAT, Lordship. 2 weeks time may be given, Lordship, for further status report.
25th January report is here.
Further report is required.
Fresh report you want.
Fresh report. Learned Government Council prays for and is granted 2 weeks further time to obtain the up-to-date status report in respect of the investigations relating to Kolgochia PS case number 183 of 2022. List after 2 weeks.
Republish.
Matter number 28.
May I plead the lordship? Lordship, LCR receive and service complete. Matter is already admitted. Therefore, it may be listed for hearing.
Let's see, receive. Matter be listed for hearing as it is submitted that the lower court records called for has been received. List for hearing in the month of May.
Much.
Matter number 30.
Please, your lordship. Lordship, in this matter, there has been a delay of 26 days in filing this writ appeal. Similar matter, delay has been convoked. Yes, lordship.
Can we have a look at the order?
Yes, sir.
Any objection, government?
No, lordship, in case of delay, no.
No objection. Heard learned counsels for the parties. The application has been filed seeking condonation of delay of
26 days.
26 days that had occurred in filing the connected appeal. Connected read appeal. Full stop. The learned counsel has submits that the delay that has occurred was not intentional and has referred to the grounds taken in the IA in support of the prayer for condonation of delay. The learned government advocate does not object to the prayers made for delay. Accordingly, upon hearing the counsels and upon perusal of the grounds urged for condonation of delay, we find that the delay has been sufficiently explained and we do not find any malafide intention or attempts adopted towards dilatory tactics in filing the IA. Accordingly, the prayer made in the IA is allowed. Delay of 26 days is condoned. IA is disposed of. Registry is directed to register the appeal and list before the court within 2 weeks.
Obliged.
Matter number 32.
My lord, there are 2 days delay in preparing the appeal. We thought that due holiday should be counted, but the registry objected, so we filed this IA for
Lordship. The copy of the IA has not been served on the BTC.
2 days delay, what do you say?
The private respondents.
But
There
they
are private
They
respondents,
are formal party, madam.
but there are respondents.
Yeah,
Yeah.
the respondents. Notice has been issued.
You should notice returnable 3 weeks.
But the thing is, last day of time, 31st March, that is why. May we be permitted to serve through Dusty?
Dusty, yes. Dusty also permitted. Mr. So-and-so learned counsel appears for respondent.
Reference number 245.
245. Mr. Bordeloy for 1 and 2, 1 and 3.
1 and 3.
1 and 3.
Make it returnable on
That may be 31st is the last day, that is why.
You'll get them served earlier.
Yes.
Okay. What
We
do
have
you
only
want?
Dusty service, you will say.
When do you want date?
Let me do on
27.
23rd of March.
All right. 23rd March.
List returnable on 23rd March.
Only Dusty, registered service may not be given, otherwise registry.
We have given you both.
Both.
You can, if you submit served by Dusty and file an affidavit, we'll take it on record.
Instead of and, it's or, that may kindly go, otherwise.
You might as well come with a written order and give it to us.
Sometimes these technicalities become problem.
All right. All right.
All right.